CJ, I hit the live stream button. It's preparing the live stream, and we should be on momentarily. We're now live.
Day councils and members of our viewing audience. Before we start our appellate arguments, I would like to take this opportunity to advise you that yesterday we observed what is known as National Constitution Day. This day is celebrated annually in the United States on September 17th and highlights the creation and signing of the Constitution of the United States on September 17, 1787. It also recognizes all United States citizens. In a democratic and diverse society such as ours, what must tie us together as Americans are our shared values. At the heart of these values and of our system of government is the United States Constitution. This document, originally written in 1787, established a framework of government that is still in place today. The Constitution organizes the federal government as three co-equal branches: legislative, executive, and judicial. The judiciary, our court system, has a special and unique role in American constitutional democracy. Americans have long looked to our courts as the guardian of our basic freedoms, protector of the rights of individuals and political minorities, and interpreters of the constitutions and laws of the land. Our Constitution is a living document whose survival depends upon each generation of Americans understanding, supporting, and actively promoting its principles and values. You have a role to play in this process. Two fundamental rights we enjoy today are the right to vote and the right to serve on juries. We hope that you will take this time to review the U.S. Constitution to enhance your civic understanding and become involved in all levels of our government. And with that, will the clerk please call the case?
This is Supreme Court case number CVA20-011 in Sedfrey M. Linsangan, petitioner appellant versus Government of Guam, Arthur St. Augustine, and Lourdes Leon Guerrero, acting in their official capacities. Respondents, appellees. Appearing for the petitioner appellant is Attorney Braddock J. Huseman. Appearing for the respondent appellee is Attorney James L. Canto II. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Huseman reserves 7 minutes for rebuttal.
So we lost our clock, and I would like the attorneys to know where they're at in their arguments. Are we going to try and bring back the clock to our screen?
Yes, CJ, we're trying now to get the clock back in so that the attorneys can visually see the time. Apparently there was some issue with the video on the clock, which was working perfectly before the attorneys joined. And so I've just readmitted the courtroom clock clerk to the meeting, and hopefully she'll be on. But if not, I would recommend that the courtroom clerk as well keep track of the time, and then maybe just send me a chat message when they're 1 minute remaining in the time that they have, and we'll alert them.
So councils, we will proceed as suggested by Justice Torres so we can get started. And I will at this time recognize Attorney Brad Huseman. Attorney Huseman, you are recognized. You have to unmute yourself, Attorney Huseman.
I think I'm unmuted now. And for the record, thank you. I'd like to let the court know that with me today is my law partner, Deborah Fisher. Good morning, Mr. Chief Justice, Associate Justices, and may it please the court. This is a case about the right to petition the government. Mr. Linsangan went before the Superior Court of Guam, and he had two relief requests, and he was unrepresented. And his first request, what I'm going to style a quarantine claim, was to stop an illegal quarantine program administered by the government of Guam. The second, which I will call an open government claim, was designed to void any decisions made during a closed meeting period. Mr. Linsangan's quarantine claim has two facets. At the Superior Court, Mr. Linsangan focused on the civil rights aspect of his claim. While the facts pled in that claim do indicate a violation of civil rights, Mr. Linsangan does not have standing to pursue a civil rights claim. But the facts contained in his complaint do indicate illegal spending and a complaint about illegal spending. And Mr. Linsangan should be able to move forward under a taxpayer claim based on the facts he pled. Mr. Linsangan's open government claim was pled and pled correctly, and that should have been allowed to go forward as well. Mr. Linsangan is before this court today because the Superior Court of Guam failed to provide an unrepresented litigant due deference. She failed to use the no set of facts standard, and the Superior Court did not even give Mr. Linsangan the opportunity to replead his case. And that was an error. With my time today, I would like to discuss the Superior Court's errors and then discuss why Mr. Linsangan has standing to pursue the relief he has requested. I'd like to turn first to the Superior Court's errors. Now, the Superior Court did make several errors in this case, but there is one error that underlies all the other errors and is repeated throughout the opinion. And that is, Mr. Linsangan was an unrepresented litigant and the Superior Court failed to provide him deference. Guam mandates, well, this court mandates that unrepresented litigants receive deference. As an unrepresented litigant, Mr. Linsangan is supposed to, Mr. Linsangan is entitled to have the court look at his complaint and determine what he's actually asking for, regardless of how he presents it. This is often a difficult task, but not necessarily an impossible one. The pleadings in this case are non-standard and not what a court is used to seeing, but that does not mean that a taxpayer claim could not be found within that complaint.
Let me just ask this question in regards to the assertion that a taxpayer claim under the taxpayer statute could be found within the ambits of the complaint as filed. Mr. Linsangan did not cite the taxpayer statute in any of the pleadings that he filed with the court, did he?
No, he did not, Your Honor.
And he also did not request in his petition for the return of any of the government funds that may have been inappropriately spent or spent without proper legislative appropriation, which is really the ultimate purpose of the taxpayer statute. So in the absence of those two provisions, you know, how is the court supposed to glean from the allegations that that was his ultimate objective, was to try and assert that he was bringing a taxpayer lawsuit for return of those funds?
Well, I would say that I don't believe that his ultimate goal was to return of the taxpayer funds. His ultimate goal was to stop the hotel quarantines. So I think it is incumbent upon the Superior Court, when presented with a list of facts from a pro se, to determine what that pro se is actually, or excuse me, that unrepresented litigant is actually asking for. So in this case, I take the court's point that that Mr. Linsangan didn't mention the Taxpayer Act, the statute itself, but the this court has held, and we've put this in our brief, that you don't need this. This is a notice pleading, not a fact pleading jurisdiction. It's a short, plain statement. He doesn't need to identify what statute he's claiming relief under. What the
Mr. Huseman, in reference to, even if we were to, and if you correctly stated that in terms of pro se litigants are given proper deference in terms of how they are treated in our court system. Faced with the allegations as pled, and Mr. Linsangan chose to be a pro se litigant in front of the Superior Court. Wouldn't the trial court be bordering on being an advocate for Mr. Linsangan if she now understanding his intentions as to the purpose of his lawsuit, then was to turn that into something else, and that would kind of exceed the deference that we generally grant pro se litigants?
Well, I would say this. I think the court is right to be wary of you do not want the Superior Court to put its thumb on the scale, right? The court is still there to weigh the party's interests, but in this case, and with most cases where you have an unrepresented litigant, you have a situation where there is an extreme imbalance of power. And in this case, you have the most extreme imbalance of power. You have an individual citizen petitioning his government to stop what the citizen has identified are illegal actions. And again, just because Mr. Linsangan doesn't have standing to assert the civil rights claim, the court was on notice that there are civil rights violations ongoing. And once the Superior Court is presented with a claim where this is the sovereign, this is the most powerful entity on the island, it is the island, with the largest law firm on the island, bearing down, attempting to get his petition dismissed. I'm not asking the Superior Court to put her thumb on the scale to help Mr. Linsangan out, but at the very least, allow him the opportunity to replead. At the very least, inform him that I understand that you want relief, and I understand you want it now. I think you should get an attorney. You have many claims here. Some of them aren't fleshed out. I'm going to give you 30 days. That isn't how this transpired. And if the litigant is given that opportunity, and if the litigant is given advised that there are going forward as unrepresented, especially with the gravity of the claims that we're talking about, that the Superior Court fulfills its duty. But certainly the Superior Court doesn't fulfill its duty if it doesn't give Mr. Linsangan at least the opportunity to replead. And I think at the bottom, at a base level, at a bottom level, the opportunity to replead should have been given in this case.
So is it your position that if obviously the trial court reviewed the petition as an invidious discrimination claim, a civil rights claim, and did not evaluate it under the taxpayer statute? So are you asking us to review that issue for the first time on appeal, or are you asking that we remand the case to allow him to replead and the trial court to examine the issue so that it develops a complete and factually developed record for us to review and appeal?
Your Honor, I'm asking you to reverse and remand the Superior Court's decision. I don't think this court needs to take a first pass at whether this complaint states a claim under the Taxpayer Act. I think that should be left up to the Superior Court judge. If Mr. Linsangan wants to replead, or if the Superior Court wants to give Mr. Linsangan the chance to replead, I think that's appropriate. What I've said and what I think the case law supports is that it isn't appropriate to dismiss the case on the first pass. That he should have been given.
you're not asking that we exercise our discretion to hear this matter for the first time on appeal.
No, you're not. No, I'm not, Your Honor.
Okay.
Mr.
And
Huseman,
one-
doesn't the taxpayer have I'm sorry, doesn't the litigant, if he's claiming as a taxpayer, have an obligation to present some facts? Throughout the brief, there's this complaint that he doesn't have facts because he didn't do discovery. Doesn't there have to be a preliminary showing of a factual basis to establish standing and all these other requirements?
Sure, Your Honor. And as far as the taxpayer claim, I think at ER 5, ER 7, and ER 10, there are discussions about Mr. Linsangan identifies the governor has a maximum cap on the amount of money she can spend. So that's $600,000 for emergency appropriation. Mr. Linsangan at ER 7 discusses how the use of funds on hotels is a waste and exceeds the government's authority under the cap. And at ER 10, my client reinforced the idea that these are illegal expenditures. And so I think Mr. Linsangan did alert the court. And this is why I say this case has two facets. It's undisputed that he did discuss the issues of invidious discrimination at the Superior Court. But he also has these references to the spending and the spending power of the governor and the illegal spending. Those have nothing to do with discrimination. They have everything to do with the taxpayer claim. They are contained in this complaint. Again, this is a non-standard complaint, but they're there.
Mr. Huseman, while this may now be an academic discussion, in light of your statements in reference to what you are not asking us to do, in reference to the merits, I'm intrigued by some of your arguments in reference to standing in the GIA case and the interplay with those principles. As I understand your argument, you make the argument that because in the Organic Act, the legislature is given the power to prescribe the jurisdiction of the courts, that GIA is unmoored from any constitutional principles that serves to limit cases that are heard, and that the legislature has unfettered power in the language that prescribes that it is entrusted with enabling what the jurisdictions of the courts are. And you make that argument based on the case in controversy, Article 3 principles as it applies to Congress. And since we don't have that similar language in the Organic Act, that non-exists in reference to that floor. But why wouldn't it be that on principles of separation of powers that emanates from the Organic Act, that may constitute the basis for the court's limitation on standing, and does not give up its powers under the Organic Act to provide for those limitations?
Okay, Your Honor, I'm happy to discuss standing. I take the court's point. So there is a separation of powers in the United States system and in Guam system. And so the Organic Act provides that this court's jurisdiction is handled by the laws of Guam. I think that's implicit, that the legislature then is given the power to and this court has recognized this before, provide rights, provide remedies. Now, what I think the court is asking me is, and you can correct me if I'm wrong, is where separation of powers comes into play. And I think it comes in this way. So we have a very similar open government statute to California's Brown Act. That's their Open Government Act. And the California courts have interpreted the Brown Act. It allows any interested person to bring suit to stop a closed meeting or the stop of a closed meeting, just like our law does. And there was a question in California as to what constitutes an interested person. Now, the California courts have come to the conclusion that interested means any person within California, any resident of California, regardless of if they're a taxpayer or not, within the system. That's what the law is set for. So this court still has the power and should use its power as a separate power it still dictates and describes what the law is. So when the legislature comes up with a law that says any interested person may bring this suit, that still requires this court to determine what that means within the confines of its jurisdiction. The point I've made in the briefs, and I think the point you're asking about, is there's a difference between this court interpreting what an interested person is and what that means within the statute. When the legislature of Guam says any individual may bring a suit, right, and it grants standing to everyone, then I understand that's in conflict with this court's holding in the GIAA case. And there is a conflict, and it is what it is. But the problem here is, if the court is going to say that broad grant of standing is invalid, it needs to find a way to rationalize it, to explain it, right? And it can't be the Organic Act, because the Organic Act says the laws of Guam control. And so
Well,
the problem.
that's where I differ with you in terms of my misunderstanding. I mean, the language in terms of the laws of Guam, in terms, and as it relates to the topic of jurisdiction and standing, it can be interpreted to mean that the legislature has the power in describing what the jurisdiction of the courts are in terms of what it's established, create causes of actions in which describes what may be heard in the courts of Guam. That's a little different from determining that the issues of justiciability from that language is written out, and the powers of the court are eliminated in reference to principles of standing as prescribed in the Organic Act in reference to the principles of separation of powers. And so I think you can read those consistently and respect the separation of powers doctrine and language that is contained in the Organic Act in such a manner without diluting the power of the legislature.
Well, I would agree with that in a vast majority of cases. In other words, this court uses what we've referred to and what the court has referred to as constitutional standing and common law standing. It uses those in almost every case it comes across. And I think those are prudential concerns, and they're valid prudential concerns. And the reason I call them prudential concerns is because there is no case or controversy, there is no particular injury requirement under Guam, under the Organic Act, okay? And so for the vast majority of cases, I think that analysis is fine. But there are three different types of laws that are really at issue here, and that were apparently at play in the GIAA case. And those are the Sunshine Act, the FOIA, Open Records Request, the Open Government Act, and then in this case, the Taxpayer Act. And those are all good governance statutes. and they allow for the people of Guam to challenge when their government takes illegal decisions, whether they meet in secret, make decisions that aren't in the open, expend money illegally. The people of Guam, regardless of their individual injury, are allowed to bring those remedies. And so if the court is going to, and I take the court's point about separation of powers, but this separation of powers cuts both ways, because the Taxpayer Act is impossible if the court is going to require particularized injury. There is no reason to have a Taxpayer Act at all if what is required is a case or controversy or a particularized injury. The federal courts are extremely hostile to taxpayer claims for the reason that they do have a case or controversy requirement in the Constitution. Lacks that case or controversy, and if the court is going to require a particularized injury, there is no way for the tax action to survive, and the court is going to have to strike down that taxpayer action and that taxpayer statute. And the problem therein becomes, then it has to strike that statute down based on, and if it wants to use separation of powers, that's one thing, but the problem quickly becomes, why can't the legislature hold the government's feet to the fire, give individual residents of Guam the ability to stop illegal funding, when the people of Guam have specifically said in that law that sometimes will not.
If I can just interject at this time, because I don't think necessarily that is the only option available to the court, is to strike down the taxpayers' stand. I mean, you've described the principles of prudential standing, and it cuts both ways. It can expand and it can limit the court's view of controversies that it may recognize as deserving special recognition, and treat it in such a fashion by seeking to interpret what the legislature meant when it granted all taxpayers the right to bring these certain types of suits. So there are jurisdictions, Wisconsin that comes to mind in reference to my looking into this matter, in which standing emanates from prudential concerns. It is not prescribed in reference to a case or controversy or a separation of powers, but it gives deference to prudential standing, and it looks at various factors, and one of being what the legislature expresses as its policy in which it's prescribing redress. Utah, in terms of the jurisdiction, if you were to look into it, does not have a case or controversy language in its constitution, but bases its principles of standing on the separation of powers in terms of how it limits. So what I'm saying is that there may be opportunities, if we ever get to the merits of the case, for the court to carve out and recognize the express desire of the legislature to provide opportunities for a taxpayer to challenge the area of illegal government spending. And so I don't see it as a all or nothing, and that you necessarily must strike down the taxpayer statute in light of GIA.
Your Honor, I take your point, and I agree with you. In other words, if the court isn't requiring a case or controversy in all cases and looks at the different statutes, I think that's appropriate, given that there isn't a case or controversy. I think actually you and I are in agreement on that point, which is to say that this court does have the ability, when the legislature passes a law, to look at what the standing is, given these are prudential concerns in Guam, and it can read and interpret what the legislature meant. This court always has the ability to state what the law is. And that's the only point Mr. Linsangan made, I think, in his brief. And that's the only point I would like to make today with regards to standing, which is this court controls the definition of standing. Respectfully, I just think that the GIAA case went a bit too far and cannot be reconciled with the taxpayer law or necessarily 80% of the open government cases. And that's the only point I would make on that. I'm running short on time, and I do want to reserve some time. I just wanted to hit 2 points quickly on the court's errors below with regards to ripeness and mootness. Mr. Linsangan's quarantine claim isn't moot. It was analyzed as a civil rights claim, but as long as the quarantines are still going on in hotels, as long as the money is still being spent, that relief can still be given. And to Justice Torres' question earlier today, just because you're not seeking to have the money returned, and Mr. Linsangan isn't seeking to have the money returned, but he is seeking to stop the illegal expenditures. And there are 2 ways to do that. The court can order it, or in this case, or in any case of a taxpayer case, the legislature could go in and bless what has been spent. That puts them on record, and then the people still have their say. If they don't like the way the money has been spent, they can vote that way in November. And if they do like the way the money has been spent, they can vote that way in November as well. It puts everyone, it creates the positive feedback loop we want in our democracy that Justice Carbolito was talking about at the beginning of this hearing. And as far as ripeness goes, quickly, Mr. Linsangan's open government claim is ripe. Ripeness deals with the timing of the injury. And in this case, Mr. Linsangan's claim on the open government deals with 4 days, months ago in March, just for the closed meeting period. And any decisions regarding expenditure during closed meetings and any decisions made during those closed meetings are, they either happened or they didn't. And Mr. Linsangan is entitled to discovery. And just one quick point, because it goes back to Justice Merriman's question about sufficiency of facts. This ripeness issue here, as it's been presented by the Superior Court and by the government, is more about a pleading, which I think goes to Justice Merriman's concerns, where it's Mr. Linsangan did not plead that an illegal meeting had taken place. Now, our position is he didn't need to plead that an illegal meeting took place, because what he did plead was the governor voided the Open Government Act and provided a way for the bureaucracy to have closed meetings in violation of the law and to keep notes of it. So the entity that knows about whether or not it took illegal acts is the government. And Mr. Linsangan, we think those are discoverable issues. The reason that states a claim is because the governor has, the statute allows for a standing for an individual to bring a claim on a breach of the law or a threatened violation of the law. And when the governor says that, or excuse me, when the governor orders the law doesn't apply and then orders that the bureaucracy should take notes when it has closed meetings, that puts the people of Guam under the idea and under the clear threat that there are going to be illegal meetings, there are going to be closed meetings, and that there'll just be a paper trail about it. And so because of the way the order was issued, because of the way the statute reads, Mr. Linsangan states a claim. But even if, to Justice Merriman's point, it doesn't quite state a claim, that's a pleading problem. We viewed it as a discovery problem, but it's a pleading problem that he should be allowed to replead. And I'll reserve the remainder of my time for rebuttal.
Thank you, Attorney Houston. Attorney Canto, you are recognized at this time.
Good morning, Mr. Chief Justice, Associate Justices, and may it please the court. So that I use my time judiciously, I will come back to the open government law claim. However, I'd like to first start with the fact that Mr. Linsangan did not plead a taxpayer statute claim, even under the most liberal notice pleading requirements of Guam Rule of Civil Procedure 8A. In the UCAL v. Wang case, this court ruled that there must be fair notice to the defendant or respondents in this case, and that was not given. Nor was there a short plain statement of the claim, as the Untitled 01 case lays out is necessary, as cited by UCAL. And more importantly, as this court pointed out in the Cortec case, which is also cited by UCAL, the complaint requires more than just labels and conclusions. And these are important, of course, because the ability for a defendant to defend against a claim requires a certain level of particularity in the allegations. Now, Mr. Linsangan does not give us the who, what, where, when, why, or how, even in the most general sense in what he says. And
didn't he assert, even though he didn't cite the taxpayer statute, he did assert that there was a waste of funds, that it exceeded the authority, that he was concerned with the spending as a taxpayer. And so if you look at 5 GCA 7103, it talks about trying to enjoin the government from expending money without proper appropriation, without proper authority. And so considering that he was a self-represented litigant and had written the pleading himself, doesn't that suggest that he was expressing a concern that the monies were being spent without proper authority or appropriation in accordance with the statute? And shouldn't the judge have taken the extra step of giving deference to him and, you know, basically allowing him to move his claims forward by giving him a chance to replead the complaint?
Your Honor did state it correctly that, and this is wherein the problem lies, that Mr. Linsangan expressed a general concern. He buried what are 4 lines that are arguably an allegation that would fall under the ambit of the taxpayer statute in 335 handwritten lines. He also did not raise the issue at all during the hearing on the motion. And he talks about that this is a waste of local funds, and he says the money should be used to buy other things. He does, and that's why I pulled the language out and set it there for the court to be able to find easily. He did allege that the governor exceeded the authority by the officials and disregarded and violated the legislative authority on appropriation. But that's all he says. When you read it within the context of his entire complaint, it's a general grievance that's being aired, essentially. And he doesn't give any other facts as to what was spent. He gives an estimate. He says by his own estimate, they must be spending this much without actually pointing to allegation based in fact. I have information and belief to allege that this hotel is receiving X money on a general range of dates, any kind of detail that would enable defendant to adequately defend, given the particularity of the allegations. Otherwise, as the Chief Justice pointed out, how is the court supposed to glean that, especially if he doesn't raise it at the hearing? And as Justice Merriman pointed out, this actually recruits the court into becoming an advocate to go farther than even the bare minimum that is required by Civil Procedure Rule 8A in terms of giving fair notice to the defendant, making a short, plain statement that that is more than just labels and conclusions. And that's essentially what Mr. Linsangan did. He aired a general grievance. He did reference the correct law, but then he says it as an aside and a complaint about how prudent the spending was and that it could be spent on something else, but he doesn't give any other facts that would constitute an allegation that we could look to the taxpayer statute and say, yes, this entity of the government spent something towards this end, and that was done without proper appropriation or in contravention of law. So it's not a taxpayer audit statute. Your Honor. It's a taxpayer action statute. And so Mr. Linsangan and no petitioner should be allowed to approach the court and say, I suspect that there is wrongdoing. And if, even though I don't have enough facts to pass the muster of Civil Procedure Rule 8A, if you allow me to maintain the claim, I'll conduct discovery and actually see if I have a valid claim that I should have pled in the first place, at least in a general sense, of allegations that are required and necessary for a defendant to be able to adequately defend when they're given in sufficient particularity. I would like to jump to the discussion regarding standing and the impact of the AB1 pet case potentially on the taxpayer statute. Mr. Linsangan basically says that the courts are restricted by the legislature by virtue of the Organic Act in 48 U.S.C. 1421-1D that says courts shall have original and appellate jurisdiction over all causes of Guam as the laws of Guam provide. Now, the Chief Justice correctly pointed out that this deals with, on its plain reading, causes of Guam, causes of action, and not necessarily standing as an aspect of justiciability, as is ripeness, mootness, and political questions. And also, Mr. Linsangan, as the Chief Justice recognized, conflates the terms jurisdiction and justiciability. So that even there, the Organic Act only speaks to jurisdiction and not justiciability, of which standing is a singular aspect. And in that regard, it does violate the separation of powers if it were to be read in the fashion that Mr. Linsangan submits to the court, because justiciability, such as ripeness, mootness, standing, political questions are interstitial in nature in terms of the essential functions of the court to adjudicate matters, as opposed to jurisdiction. And they are somewhat akin to fundamental rights of individuals constitutionally. You can't exercise your other rights without certain unexpressed fundamental rights being recognized or in play. And that is akin, that's a sloppy analogy, but akin to the function of justiciability. And I only point that out to contrast it from jurisdiction, which should not be conflated. They should not be conflated, those two terms. And that's why the restriction on advisory opinions is something that is important to the separation of powers and the essential functions of any court.
I think Mr. Huseman seemed to acknowledge clearly that the separation of powers principles, provides the court the opportunity to exercise, prudential, for example, standing and other issues. But the GIAA case did not really address any of the separation of powers issues, and it did not rely upon separation of powers as a basis for determining that our standing requirements trump legislative directives. So it seems like that seems to be part of the frustration, for lack of a better term, expressed by Mr. Huseman, is that, if we don't have a constitutional minimum standing requirement because the Organic Act doesn't have a case of controversy provision. And so if the court is going to determine that we are not going to follow a legislative directive in a particular area, we should set forth our basis for that decision. And at least in the GIAA case, there was no discussion of, I don't believe, separation of powers as a basis for providing the court the ability to determine, even in the absence of a case of controversy requirement in the Constitution, that we can, while the legislature can extend jurisdiction, create causes of action, that the courts have the justiciability ability to decide and review standing requirements.
I wholly agree with Your Honor that I agree with Your Honor that that was not expressed in the AB1 PAT case, and maybe it is necessary to alleviate some of the frustration and misunderstanding of the roots of this court's inherent power regarding justiciability. But this court did also touch upon.
If we address the merits, if we even get to the merits, I don't think
Correct.
we get, unfortunately.
Now, Mr. Canto, in reference to your efforts to try and strike a balance in reference to that GIAA should not stand for the total abolition of the legislature's express intent in wanting certain causes of actions to be heard by the court, despite the standing requirements, constitutional standing requirements, and express that by passing the taxpayers statute. You put forth a suggestion that maybe in interpreting this statute, we look at, I think it was Pennsylvania, the four-part test that the court carved out to strike that balance in reference to preserving constitutional standing principles for the majority of cases. But in the area of taxpayers lawsuit, there's policy reasons why we want to allow such controversies that doesn't satisfy the traditional constitutional standing requirements to be heard by the court. Now, in reading the cases that you have cited, the Pennsylvania Supreme Court carved out that four-part test based on a common law statutory discussion. And so I can understand that if we were confronted without a taxpayer statute and that there is such a lawsuit that maybe developing the common law in similar jurisdictions may give us that opportunity. But here we have a taxpayer statute that we must interpret, and we can't say, well, it means this in reference to looking at Pennsylvania, because to me, the framework is a little different. And so we are constrained in trying to glean what the legislature meant when it passed the taxpayer standing statute as to its intent. So maybe that's not the best example. Do you have any response? Because you didn't talk about that distinction, and I'm struggling, even if I wanted to follow your suggestion that the analysis doesn't lend itself to a similar circumstance in us looking at the taxpayer standing statute.
Thank you, Your Honor. Yes, the court did that with the open government law in the AB1 PAT case. You have a similar statute that is intended to be applicable to all persons, essentially to hold their government accountable. And in that case, the court pointed out all that was necessary is for, in that case, someone requesting documents that be released after the 6 months executive session. You have to request them. You have to somehow personalize the injury and concretize it to give you that common law standing necessary and fall within the zone of interest of the statute for prudential concerns. Here, and in Mr. Linsangan's case, for his open government law claim, it's the same. He has to attempt to attend a meeting in order to be blocked from attending and have a personalized injury for which he would satisfy the court's concerns as just expressed. For a taxpayer statute, it's a little trickier. I do think that Bennett v. Speer does have some influential capability on this court to say that everyone is within the zone of interest as a prudential concern as expressed by the intent of the statute, and that's hard to shy away from. but I think it's almost necessary to be able to bring it within the realm of its rationale in AB 1PAT regarding the open government law to analogize and say there has to be some indicia of personalized injury. What that looks like is frankly unclear now, but that's why I suggested certain parameters, just like Pennsylvania carved out, to try and better, as I keep repeating, personalize the injury so as to avoid these altogether advisory opinions that are essentially expressions of political questions, whether what another branch of government did was right or not. But that sense of a wrong to an individual who would come before the court is essential. This court has already acknowledged its importance in the Maeda Pacific case when discussing the term justiciable controversy. And just because the Organic Act does not create a case or controversy requirement does not mean that this court cannot adopt it in terms of determining what its guidance, what its lanes are for justiciability rule imposition. So you have to have someone who is wrong to come before the court, and that's one of the most primary reasons why courts are in existence in our government. So that's why
if that is going to be the standard, I think as Mr. Huseman points out, taxpayers filing such a lawsuit in terms of illegal government expenditure doesn't lend itself to that analysis, because they are not going to be able to show that they are individualized, particularized injury separate and apart from any other taxpayer. And so that will be contrary to the constitutional standing analysis. And my difficulty with following your suggestion is the basis in which the Supreme Court of Pennsylvania carved out that test. And that was based on a common law statutory review, as opposed to the Congress or the legislature of Pennsylvania announcing via a statute that it wants a certain type of dispute to be able to be heard in the court, and there then it becomes a statutory interpretation, and maybe consistent with the principles of prudential standing, we may be able to enlarge the areas in which the court will entertain lawsuits absent the traditional case or controversy circumstance, to recognize the policy of the legislature and the very important issues regarding illegal government expenditures.
I agree, Your Honor, and I do share the same concerns and agree it is problematic. It may be possible for this, especially because it's problematic, especially because that law was passed in an environment where we had, it even says it in the law, an appointed attorney general who, by the public's perception, was not responsive to illegal government spending. We now have an elected attorney general. We have a public auditor. We also have Title V, Chapter 22, which makes it misdemeanor for any government spending that is not lawfully appropriated. But I think it is possible for this court, within the realm of prudential standing analysis, to possibly deem that the injury is in fact suffered by all persons of Guam, however diffuse or reduced in degree, that the taxes that are collected are spent for the entire public good, and everyone has 1/1,000,000th of a share in that.
Would the government be concerned at all that if we were to go down that line, that we will be opening up the floodgates to lawsuits that challenge a difference in priority of expenditure and that if we now interpret the taxpayer statute that says literally any taxpayer can come in and that he or she may disagree, that instead of spending funds for quarantine hotels, that it'd be better served to spend that money on PPEs, and that we then are to step in and decide which priority better serves the taxpayers of Guam.
Your Honor, the government does not have a concern because that's how the statute's been expressed so far. And as I stated in my opposition brief, it doesn't seem to have opened the floodgates as of yet. But of course, there's always an ongoing concern about the court being placed in a position to have to issue advisory opinions. Now, the government takes no position other than that of intellectual honesty regarding the law, and will rely upon the court's issuance of that law. And I think that's our duty as the government, to not necessarily advocate a position. And I don't have the evidence to raise the alarm that there will be a flood of general grievances. But as long as they are, unlike what Your Honor stated, not an accusation that the money should be better spent, but that it was spent illegally or without lawful appropriation. And that would be the government's position, Your Honor. And I wish I had a better suggestion for the court, and I think it may fall within an interpretation of prudential standing as intended by the legislature, if anything, to be able to continue to maintain that law on the books.
Mr. Canto, I'd like to ask about a different issue. Generally speaking, dismissal is considered an extreme sanction imposed upon. Dismissal is considered an extreme sanction when it's imposed on a party. Here, the litigant is simply asking the case be remanded so they can restate their claim more clearly. Why does the government feel that's not appropriate or proper?
Your Honor, because he did not adequately state a claim. It wasn't his intent, and it's brought up here in hindsight that he, as I stated, it airs general grievances in the way that it's expressed in the complaint. I don't think that the trial court, who properly addressed the matter within a very short period of time, as it was required under Title 10, Chapter 19, because of the emergency, the public health emergency, he didn't raise it at the hearing. We had no idea that this was his claim, and I don't think that it's adequately expressed enough for the government to be able to defend against it. So that would be the reason. I don't know that the trial court's role is necessarily to be that of almost an advocate to say, well, here you have 4 lines out of 335 where you do complain about the prudence of spending, but you also do reference a law very briefly and make a generalized accusation that that spending exceeded appropriation under that law. But it's almost an aside. And so there must be some fair notice. There must be more than labels and conclusions to form a proper claim under Rule 8A. And he just didn't do that.
So you think finalities are more important public policy than allowing the litigant to go forward?
Your Honor, if he had a claim, he would have been able to express it enough, even in his capacity as a pro per individual. And he didn't point to anything. If you read the lines that I extracted, and within the context of the entire complaint, his concern was about what he termed invidious discrimination, as well as the open government law claim. And this was really an aside, and it's only an afterthought now by a skilled practitioner like Mr. Huseman and his assistants of Mr. Linsangan to say, well, this should be a claim that's brought forward, but there's no details about it. And that's why, in terms of the balance against the importance of individuals being able to approach the court, that he didn't bring anything here. And I don't know that remanding it would allow him to do so either. Otherwise, if he had facts or even on information to believe, he would have brought them, and I don't see any reason why he wouldn't have at the time, if it was enough of concern to actually allege that as a claim or cause of action in his case. And with the remaining time, if I may, I would like to respond to statements made about the ripeness argument raised by Mr. Linsangan in terms of his open government law claim. There's a distraction made about what the timing of the injury was, and that's not the concern of the ripeness doctrine in this context, because what it talks about are contingent events that have yet to occur that would cause the claim to fail for lack of ripeness. Here we have a set period, granted, but it also relates to the lack of adequate pleading under Rule 8A in terms of the open government claim. He needed to at least allege that there was a meeting and the public was denied from that meeting. But at any point in time that he makes that allegation, these are contingent events for which he does not even allege occurred, even if they could have only have occurred during a 4-day period in between those executive orders. And that's the contingent event which normally in a ripeness analysis has yet to occur, but that's only if it occurs at all. And that's the case here. And that's why ripeness is the reason for the claim failing or lack of ripeness, as well as the mootness as I expressed in the opposition brief, and a lack of standing as well. And I think with that, I will rest, and I thank the court.
Thank you, Mr. Acanto. So, Mr. Huseman, I can't recall how much time you have remaining, but maybe the clerk will put that back up. And you may proceed and use your remaining time.
He has 1 minute, 24 seconds, Chief Justice.
Thank you.
I will try to be as brief as I can.
Or talk fast.
Or talk fast. I take the point as far as audit versus action. Action. I think the taxpayer statute is a taxpayer action, not a taxpayer audit. But again, that's a pleading problem that can be addressed. It's not a dismissal problem. Mr. Linsangan is entitled to at the very least, what a represented party would receive, and that's at least one more chance to replead. I wanted to talk quickly about standing and the GIAA case and the open government law and the open meetings law and the taxpayer law. The government indicates that it believes that you have to attend a meeting to have standing, and Mr. Linsangan would vehemently disagree with that. I believe this court, in its previous decisions on the Open Government Act, has disagreed with that. The Johnson case, and I can provide a cite if the court wants, but the Johnson case, Joseph case deals with an individual who is complaining about the actions the dentistry board, I believe, took against him, and that they didn't follow the proceedings of the Open Meeting Act correctly. The government board there tried to cite to Nebraska cases, indicating that if you don't object while you're at the meeting, your case is waived. This court rejected that idea. It cited to a Rhode Island case in Joseph's case, where the individual and the court's really quite clear on this, the Rhode Island, is the individual didn't show up to the meeting. The government incorrectly labeled what was going to go on at the meeting. He found out later and then brought suit. And this is where all these laws, the open government law, the taxpayer law, and the FOIA law all kind of fit together into this governance framework. So if a government of Guam agency decides to have a meeting, an illegal meeting where they give themselves raises, right? They didn't tell everyone that they were going to give themselves raises. They do this in secret, and then surprise, they all have raises. It can't be the position of given the statutory framework we have in Guam, it cannot be the position that if you didn't show up to every government meeting to double check what those government agencies are doing, then you don't have standing to stop the illegal behavior the government engaged in. The Open Government Act explicitly says the people of Guam do not give up their sovereignty, and that the bureaucracy serves them and not the other way around. Forcing people to go to every public meeting to make sure the government is doing their job correctly inverts that. It puts it on its head. It changes the statute's meaning from the people are sovereign to the bureaucracy is sovereign. And so we would disagree with that. And if the court is interested, I have a comment on the GIAA case, but I see that I am completely out of time.
Your time is up right now, Mr. Huseman, and you may have another opportunity in the future. And so do the justices have any other questions before I conclude this hearing? For Mr. Huseman, in 1 or 2 minutes.
I have no further question.
All right.
I do not have any further questions.
All right. Thank you, counsels. You did a very good job on both of you. This case will be taken under advisement, and the court stands adjourned.
Thank you, Your Honor.
Thank you, Your Honor.
Goodbye.
Aye.